Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about is how self-represented individuals can subpoena somebody to court. So basically ask the court's permission to compel that person to show up to testify. So this does not apply to attorneys. If you have an attorney, you don't need to watch this video. You should just discuss it with your attorney because attorneys have the power to subpoena somebody to court or to a deposition without needing the court's permission to do so in most cases. But self-represented people, they can't just subpoena somebody to court. They need to ask the court's permission. So the statute that allows them to ask the court's permission, or I should say the Connecticut practice book section, is section 7-19 of the Connecticut practice book. So what this section says in subsection A is that self-represented litigants seeking to compel the attendance of necessary witnesses in connection with the hearing of any matter shall file an application to have the clerk of the court issue subpoenas for that purpose. The application shall include a summary of the expected testimony of each proposed witness so that the court may determine the relevance of the testimony. The clerk, after verifying the scheduling of the matter, shall present the application to the judge before whom the matter is scheduled for hearing, or the administrative judge, or any judge designated by the administrative judge if the matter has not been scheduled before a specific judge, which judge shall review the application. It goes on to say that the reviewing judge may act on the application ex parte, so without the opposing side, having the ability to object, it's outside the presence of the opposing party. So the reviewing judge may act on the application ex parte or without the opposing party, and may direct or deny the issuance of subpoenas as such judge deems warranted under the circumstances, keeping in mind the nature of the scheduled hearing and future opportunities for examination of witnesses as may be appropriate. If the application is granted ex parte, in whole or in part, any party may file a motion for protective order or motion to quash as appropriate. So, if a subpoena is issued, the opposing party can file a motion protective order or a motion to quash, basically trying to wipe out the subpoena and say, oh, this person does not actually have to come testify. So that's a separate process. I have other videos on that. So the fact that the court issues a subpoena does not remove the opposing party's right to file a motion for protective order or motion to quash. If an application is denied ex parte or in whole or in part, the applicant may request a hearing which shall be scheduled by the court. So if your application is denied, just request a hearing and you can have, you can give additional statements to the judge for why the subpoena should be issued to try to get to them to change their mind. The reviewing judge may order that an application acted upon ex parte be placed in the official court file, whether or not a hearing is requested. If the reviewing judge does not act on the application ex parte, so outside the presence of the opposing side, such judge shall direct that the application be placed in the official court file to allow any party to file an objection, which objection shall or will be filed by a date to be set by the reviewing judge. Having provided an opportunity for any party to object, the reviewing judge may direct or deny the issuance of subpoena as such judge deems warranted under the circumstances, keeping in mind the nature of the scheduled hearing and future opportunities for examination of witnesses as may be appropriate. So they may just grant it or deny it without the other party weighing in, or they may, put it on hold, give the other side an opportunity to object, and then make a decision after that. And then any party or non-party to whom a subpoena is directed pursuant to this rule may file a motion to quash or a motion for protective order as appropriate, which I already talked about. All right, so that's the rule that governs this. Now I'm going to show you how to actually do it. So if you just do a Google search for application for issuance of subpoena, you'll find this court form. I'm not going to put the form on the website because these forms are updated periodically. So you want to get this from the judicial website to make sure that you have the most up-to-date form. This form number is JD-CL-136. So you fill out the form, you put the judicial district where your court is, or where your case is. So that might be New Haven or Stanford, or, there's a whole number of judicial districts. It's the caption at the top of your case. Or if it's housing, this is generally applying to divorce cases, but really this can be done in any civil case, or criminal, I believe, but I don't know so much about that. I'm talking about this in the civil context. So, the judicial district, and then so the town where it's located. So those are two separate captions. In New Haven, for example, it's the New Haven Judicial District at New Haven. But Bridgeport is Fairfield Judicial District at Bridgeport. And then you put the docket number for your case and the name of your case. So plaintiff versus defendant, and then check off the type of case it is. So civil, housing, family support magistrate, or criminal motor vehicle. So this application has a lot of the language that is in the practice book section that we just talked about. And then here it says that, you understand that you have to have the person who is being subpoenaed, you have to have them served if the subpoena is granted. So if the court issues a subpoena, you then have to take the subpoena form, give it to a marshal, and have the marshal serve the person. So then below, you basically follow the instructions. You check off this box if appropriate, and then you put the name. If you're asking for multiple people to be subpoenaed, you can include those in, the second section. So you put the name of the person's address, who you're hoping to have subpoenaed, and then you fill out these questions. So why you believe the testimony from this person is necessary. I believe that the person will testify that, and then, state what you anticipate they will say. Obviously, you don't know exactly what they're going to say. So just, fill that in to the best of your ability. And then if you want them to bring certain documents with them, so bank records or, I don't know, security camera footage or receipts from a business, things like that. Whatever you want them to bring to court with them, you fill that in here. So then you go down below that, and then you check off the court date that you want them subpoenaed for. So the trial or hearing date that you want them to come for. And, if you know who the judge is, fill that in. You basically fill in what you want them to be subpoenaed to court for. And then you sign that, you sign it, print your name, phone number, and date. So you give this form to the court. Everything on this order below, this is for the court to fill out. The judge will basically grant it or deny it. So you submit this application, and then you also have to submit, the actual subpoena with the top information filled out. So again, just put the name of the case, the docket number, the judicial district, and the address of the court. And they fill in the name and addresses of the person or people that you're trying to subpoena to court. And then everything else is for the court to fill out. So this is the actual subpoena. If the court is, although I said person or people, if you're asking for multiple people to be subpoenaed, you should probably do separate forms here. So if you're asking for 2 people to be subpoenaed, do 2 of these and put their name and address. And then, the court will fill this out if they do order the actual subpoena, and then you have a marshal serve the actual subpoena, or you can do a fee waiver, which is a separate process, which I can talk about in another video. So those are the basics on how to subpoena somebody to court if you are a self-represented individual. As usual, if you have any additional questions, please feel free to contact our office. And if you are looking for representation in a divorce or family law case, we would invite you to contact our office as well.